Good evening, ladies and gentlemen. I am the marginal non-hermit, and today I have a little, I wouldn't say I scripted it, but I've got some notes here, and I'm gonna talk a little bit about labor unions because I've been hearing a lot about them recently, and I've been hearing the argument a lot that treats American labor unions as if they are a free market phenomenon, which they are not, which I will demonstrate. But in addition to that, that also weakens the argument for labor unions in general because it is possible for there to be voluntary labor unions. So with that in mind, let's dive right in. So voluntary labor unions, let's just kind of start there. What would a voluntary labor union look like? Well, it would look like a few people, or a group of people, let's say a group of clockmakers, who all decide that what they want to do is they want to work together as a group to negotiate better salaries for themselves. Now, obviously, they can't change any of the rules of economics, so the way that they would do that is basically by attempting to restrict supply. So if they restrict supply of their labor, then they can negotiate a higher price for their labor. Now, that means that they have to be exclusive. That means that certain people who would be clockmakers but don't join the union are disallowed from being clockmakers, and they would have to make this disallowment happen in a voluntary way by, say, making contractual agreements, voluntary contractual agreements with employers who employ clockmakers, something like that. This exclusivity would lead to wage increases if it worked. It would require voluntary contracts to have these kinds of points in them that restrict non-union clockmakers from working as clockmakers with a large number of employers. And the threat is perhaps a strong word, but the idea would have to be that if the contracts are broken or if the members of the union don't get what they want, that they have the ability to collectively strike, so that the members of the unions themselves have a agreement between each other that if basically some small fraction of them finds the work situation intolerable, that all of them will quit, leading to higher negotiation power. So that's kind of what a voluntary union would look like. You couldn't actually do pickets because pickets would be that would be blocking property or taking place on property owned by the employer. That's no good. But you could have contracts that say that the employer agrees only to hire these union people under some sort of monetary penalty if they decide to do otherwise. That's how most contracts are enforced, is by a clause that says that if you don't do X, then you pay Y. And those kinds of unions, voluntary labor unions, would, in a free market, be able to exist, be allowed to exist, and be allowed to have whatever influence they can gain for themselves by voluntary means. However, what the people who are promoting unionism in the U.S. will often fail to tell you is that there are a variety of laws that turn American labor unions in particular. This isn't true of every country, but I'm going to talk only about the United States in this example. If you're in a different country, you may have to look up what laws there are that enable or privilege or disable labor unions, because anything you're going to get is going to have a combination of all that. But there are basically three major federal laws that coordinate or control how collective bargaining has to happen. And I'm going to go through those one at a time and also give a little bit of economic analysis from a few different economists, and hopefully this will clear up why labor unions in the U.S. are not really a free market phenomenon. They have a lot of privileges from the state that they would not have in a free market. So let's get into it. The first law that we're going to talk about is the Norris-LaGuardia Act, and this was the first major federal piece of labor legislation. All of these happened in the early 1900s, over the space of, I think, around 20 to 30 years. So I'm pretty sure that the Norris-LaGuardia Act was sometime in the 30s, question mark. The Wagner Act is going to be the second one, and then the Taft-Hartley Act was in the I think the late 40s or possibly the early 50s. In any case, the Norris-LaGuardia Act did a couple of things that are important. First off, it invalidated in courts what are called yellow dog agreements. A yellow dog agreement is an agreement between an employer and an employee that the employee will not engage in union tactics, will not join a union, will not do that. And this kind of contract is a valid and reasonable contract. Of course, for making that agreement, you would expect that the employee would get some kind of recompense for that. However, the Norris-LaGuardia Act basically took these contracts and said these contracts will no longer be enforced by courts in any way. And what that does is it makes it so that unions have this protection that they didn't have before. This isn't a very major protection. This is a pretty minor one. But what it basically says is that the employer cannot make as a condition of employment an agreement that employees not form a union. And of course, such an agreement, if made voluntarily, would be reasonable, or not necessarily reasonable, but would be allowable. But by invalidating these agreements, basically what happened is that a lot of existing agreements that had already been made were invalidated. That's a state intervention, and it made employers have to change the way that they interacted with their employees and prevented them from making these sorts of agreements in the first place. In addition, and this is a more important one, part of the Norris-LaGuardia Act, the Norris-LaGuardia Act exempted unions from prosecution under the Sherman Antitrust Act. So the Sherman Antitrust Act is the act that handles monopoly and big trusts and stuff like that. And, basically what this act, what the Norris-LaGuardia Act did in this respect is saying that the unions are in most cases exempted from prosecution under the Sherman Antitrust Act, which that act was designed to prevent monopolies, and by making it so that unions can have monopolistic tactics, that gives them a fairly strong lever against employers, and especially a good way for them to increase their reach, is what I'll say. So that one wasn't so bad, but soon after came the Wagner Act, also known as the National Labor Relations Act. And that one is the real kicker. So what that act says is that if a majority of workers at any time vote for a union, majority, and that union represents all workers in this subgroup and can force them to join and or pay dues. It established a board called the National Labor Relations Board, which actually defines arbitrarily what a worker group is for the purposes of this vote, which is already a problem, right? Because it can basically narrow or expand that as it pleases in order to achieve the goal that it desires. An interesting point here is that the union, once voted for, is never required to stand for re-election. So even years later, after all of the people who voted for the union have left the job or retired or something else like that, the union still has power over the new workers that have come in who never voted on it at all. In fact, it's much more difficult to decertify a union than it is to certify a union. The third major point of the Wagner Act is that employers must bargain, quote, in good faith, end of quote, with the union if there is one that is elected. And this is vague, and it is interpreted by the pro-union National Labor Relations Board already, so it's already a pretty heavy finger on the scale in favor of unions. But the problem with this, of course, is that it's extremely strict against the actions of the employer. It requires them to be silent with regards to unionization before the vote. And it also leads to a gamesmanship problem. Basically, the only proof that an employer has that he's bargaining in good faith is that he has made concessions. And so it requires the employer to basically put something forward that he doesn't expect to get accepted, and then they have to bicker over the things. It creates an artificial antagonism where it doesn't necessarily have to exist. Now, I'm not saying that there isn't sometimes antagonism between employers and employees. Certainly there is. But this is a big carrot in the front of the face of making up such sorts of negotiation games. there were additional things in there. For instance, if the union group goes on strike and some of the strikers commit violence, the violence of strikers is excused as animal exuberance, and the employer must rehire them after the strike, even if they've done physical damage to people, etc., etc., etc. It is a Not only does it make it so that the employer has to rehire very hostile people that they otherwise wouldn't hire, but it also makes it so that the people who are striking are seen as not having, what's the word? Like free will, right? Oh, if they did something violent, well, we can't really have any problem with that. I mean, and from what I've read, there are some fairly extreme cases where this was upheld. So it wasn't just like a paper tiger as far as it goes. In addition, this is the real funny kicker, is that the Wagner Act protected the union from prosecution, even if it actually advocated violence against the employer. This is a real crazy thing, but basically this enables union groups to physically intimidate employers and customers. They can block shipments, things like that. These are things that they could not do in a free market system. Now, there was a little bit of backlash from this, and later on the Taft-Hartley Act passed, which the Taft-Hartley Act did a couple of things. One thing it did is it is the source of the commonly heard right-to-work legislation. So states or whatever could pass legislation that said that it was illegal to have union contracts that required exclusivity. So this was kind of a bite back against the Wagner Act in some ways, but in typical state fashion, it creates one problem and then creates a second problem in order to quote unquote solve the first problem, because of course, as we know by now, the right to work acts and such in various states are major sources of contention, where if this hadn't gone through this way and we hadn't patched one bad law with another bad law, that would be a problem. But the other thing that the Taft-Hartley Act did, which you might not know about, is that it clarified the in good faith clause in the Wagner Act to say that you could have free speech, but there could be no threat of reprisal or force or benefit from the employer to the employees who are planning or thinking about unionizing. Now, the problem with this is that it has a loophole that you could drive a Mack truck through, if you were a Teamster. Sorry, bad joke. But the problem is that that practically any statement of fact could be seen as a threat of reprisal, force, or benefit. For instance, in 1969, there was a Supreme Court case that said that held that employers cannot even refer to previous events. There was a company that unionized. Then there was a strike. It completely paralyzed the company. The company had to completely reorganize, basically fire a huge number of people, completely restructure itself. And then later on, and I don't mean 6 weeks later, I mean years later, they were starting to put together votes for a union election again, and the employer said, well, look, I mean, the last time this happened, we saw what happened, so I just want you to be aware of that. And the court and the court not only ruled that was not, that was against the in good faith requirement, or the threat of reprisal / force / benefit requirement, but it also set aside the election results, which went against the union, and ordered the employer to bargain with the Teamsters without running a second election to see if they could, put that genie back in the bottle. Basically say, look, you're not allowed, you as a voting member are not allowed to consider the statements that the employer made about the previous unionization attempt. Those are the three major labor acts, and as you can see, they are pretty strong interventions, usually on the side of labor unions, that make labor unions in the U.S. in particular a non-free market occurrence. They're highly privileged by government fiat. And just to finish this off, I'll give you guys a couple of quotes from a couple of economists. About labor unions, first we'll start with a quote by Edward Chamberlain of Harvard in his book, The Economic Analysis of Labor Union Power, on page 41. He says, if A is bargaining with B over the sale of his house, and if A were given the privileges of a modern labor union, he would be able, 1, to conspire with all other owners of houses not to make any alternative offer to B, using violence or the threat of violence if necessary to prevent them. 2, to deprive B himself of access to any alternative offers. 3, to surround the house of B and cut off all deliveries, including food, except by parcel post. 4, to stop all movement from B's house so that if he were to, for instance, a doctor, he could not sell his services and make a living. And 5, to institute a boycott of B's business. All of these privileges, if he were capable of carrying them out, would no doubt strengthen A's position, but they would not be regarded by anyone as part of bargaining unless A were a labor union. The great Walter Block says, the philosophy of free enterprise is fully consistent with voluntary unionism, but is diametrically opposed to coercive unionism, as we can see from the descriptions of the laws. And the great Friedrich Hayek, from a state in which little the unions could do was legal if they were not prohibited altogether, we have now reached a state where they have become uniquely privileged institutions to which the general rules of law do not apply. And I have some sources in the description for additional reading that you might want to get to. If you are interested in this topic, I highly recommend that you look into it because there's a lot going on. There are a lot of really crazy court decisions, and the laws themselves are quite clearly, malicious in a kind of statist sense. So with that, I will say thank you for watching, and remember that whenever someone tells you that something is a free market institution, always look behind the curtain to make sure that there aren't any laws that are hidden there that give one party or another privilege under the law in particular and the force of the state behind them. Thank you.